So generally your will is private during your lifetime, and the person that makes the will is able to make it private or share it around however they like. So they might choose to not show anyone during their lifetime, or they might choose to share the will with family or friends or loved ones, or perhaps the people that they've appointed as executors or nominated as beneficiaries in their will. Another scenario where a will might be shared is if the person is under control of an enduring power of attorney, and their power of attorney document allows their attorney to view the will. And that might be done because they want their attorney to have in mind what specific gifts or other gifts they've made in their will, so that should the attorney have to sell an asset or deal with an asset to pay for care or accommodation for that person, the attorney can check what's in the will first before making a decision to sell something. During your lifetime, the will is private, and then once the will gets admitted to probate, if it does have to be admitted to probate, then it becomes a public document. So it's important to keep in mind that anything that's in your will after it's submitted to probate will become public record, and oftentimes that can lead to an interesting discussion with people who might want to include certain words or certain comments in their will. And it's important to just keep in mind that if there's something that might upset someone or offend someone, it probably should just stay out of the will.
No, you don't have to carry out a reading of the will. It looks good on television and in movies, but it's not strictly required. But if a beneficiary of the estate is asking about their entitlements under the will, you should show them a copy of it. So a grant of probate is a document that is issued by the Supreme Court in the relevant jurisdiction, and it confirms that that was the last will of the deceased person. So a copy of the will be annexed to the grant. And it also gives the executor sort of a document to show that they have the authority to deal with the deceased's assets.
And you only usually need probate for specific assets. So if you hold real property, meaning land, anything, you will need a grant of probate. You will also need one if you have bank accounts over a certain value, things like that. If you have a very small estate, there's not much in it, then you won't need a grant of probate, but typically most people will need one. If a person dies without a will, they're considered to have died intestate, and that means that somebody who's authorised under the legislation needs to apply to the Supreme Court again of the relevant state or territory for a grant of letters of administration.
The person who is entitled to administer your estate, if you die intestate, is called the administrator, and the administrator is determined again according to legislation. So it will depend on their relationship to you. And usually it's your closest surviving relative that would be taking on that role if they're willing and able to. You don't always need a grant of probate. So if your assets are held jointly with another person, or if they're held in trusts, you wouldn't need a grant of probate for those assets if they're not held in your legal name. And you also often won't require a grant of probate if the estate is small. But you will need it if you have assets like real estate, if there's an accommodation or nursing home bond in the estate, or if you have significant shareholdings or funds in bank accounts.
To get a grant of probate, the timing is really dependent on the Supreme Court's capacity. So sometimes, particularly in South Australia, we've been getting grants back within a week, whereas previously it's taken months. So it really depends on the probate registry's, capacity at the time. But typically we like to tell clients that it is a couple months because that's about the general time frame.
Well, when you're gathering information for probate, you're always relying on institutions to give you information. So if their processes are delayed, the time in which you can apply for the grant will be delayed as well. But the other things that can delay a grant of probate usually are around the circumstances of the will. So if there's anything about the will that would indicate to the court that it's not valid for some reason, such as there being different coloured pens or sections of the will that have been crossed out and not initialed, if the will has been damaged in any way, If it hasn't been signed strictly in compliance with the Wills Act, then, or the relevant Wills Act, then there might be a delay as well. It really just depends on those sort of circumstances and what the will physically looks like.
The best way to deal with a requisition is obviously respond and address the requisition as best you can. Sometimes it can be really simple, such as there's a name change and the registry may just require an affidavit confirming that name change and why it's happened. Or it can be more complex. You know, for example, somebody has died in a place that's not got a particular location on a map and they need to confirm where they died for the purposes of the death certificate. It can be all sorts of things. It can be really complicated or quite simple to address.
Usually to get a grant of probate, the main documents you will need is the deceased's original will and the death certificate. If you don't have the original will, there are other processes that you can go through, but it will make your application a bit more complicated. But other than that, you just need to have a good understanding of what the assets and liabilities are in the estate as at the deceased's date of death.
You need any other documents relevant to the application. So it might be affidavits if that's necessary, explaining maybe something in the will that needs explaining, or letters to the registry if there's other things. For example, one of them I did recently is because the estate had a really small value and the probate registry was likely to ask why we were applying for probate, given it was such a nominal value. And we wrote a letter to the registry explaining this in anticipation for a requisition. So if you think there might be a requisition, it's probably worth, in our view, addressing that head on so you can avoid any delays in actually being issued the grant of probate. For a grant of letters of administration, you need what's called an oath of administrator in South Australia, and that is a document where the person applying for letters of administration agrees that they will administer the deceased estate in accordance with the law. They undertake to do all things necessary and legally and to the right people. You also need the death certificate because it confirms the person's death, has information about it, and then again, any other documents that would be relevant to the application you're making.